The court is going to call the first-degree murder case of People versus Chris Bachmeyer. I note that we have 100 jurors waiting for us to bring them to the courtroom to begin jury selection. Is the defendant ready for trial?
Apparently, Your Honor, there's a little problem this morning.
Yes, there's a big problem. I would like to have a new lawyer. This lawyer has not done anything on my case. I am charged with murder. I could actually stay in jail for the rest of my life, and he doesn't care. He never comes to the jail to talk to me. He hasn't shown me anything, and he shows up today. I don't even think he's ready. I want a new lawyer, and I want one now. He's fired.
Judge, you know me. I've been in front of you 100 times. You know my abilities in the courtroom. I don't think I've lost a jury trial in this district in 10 years. I'm ready to go on her case.
He's not ready, Judge.
We've worked hard.
Do you hear that? We have not worked hard. I have asked him several times to have my mother testify. He will not let my mother testify. She knows all about me. She understands my case. She could get me off of this, but he refuses to bring her over here.
Your Honor, you know that defense counsel have the ability to establish their own trial tactics. That's all this is about.
He doesn't have trial tactics. I don't think he's ever been to trial. He's a public pretender. He doesn't know anything about doing trials. And I am afraid that if I don't get a new lawyer right now, this is going to go bad.
Judge, you know what? That's fine. I don't object.
Great.
Let her get a new lawyer. Let
Great.
her represent herself. I have 100 other people outside that are waiting to talk to me.
So give me a good lawyer. I need it.
I'm going to take a 15-minute recess to research the legal issues that counsel and the defendant raise. I'll be back in 15 minutes. This bench basic is about the right to counsel. The scenario that you just saw plays out every day in real life in open court and usually on the first day of a first-degree murder trial. A defendant has a constitutional right to self-representation. The case site is People v. Alangi. It's in the materials that we've submitted and that are available to you. The right to self-representation may be asserted affirmatively by the defendant or by inference when the defendant declines to be represented by counsel. The site for that is People v. Arguello, 772 Pacific 2nd, 87 at page 92. That is a Colorado Supreme Court case from 1989. The defendant has a right to self-representation. The defendant does not have a right to hybrid representation by both counsel and the defendant, although a trial court in its discretion may permit this. A defendant's right to self-representation is conditioned on the requirement that a defendant has an intelligent understanding of the consequences of doing so. Thus, before a defendant is allowed to proceed pro se, the defendant first must effect a valid waiver of the right to counsel. People v. Arguello. The waiver of the right to counsel. A defendant may waive his right to counsel in two ways. One, by express waiver after full advisement by the court, that's also known as an Arguello advisement, or by implied waiver. Effective waiver of counsel is a mixed question of fact and law. People v. Alangi. A waiver is an intentional relinquishment or abandonment of a known right or privilege. A trial court's determination that a defendant waived the constitutional right to counsel will be upheld if the record affirmatively establishes that the defendant knowingly and intelligently waived that right. People v. Arguello. The courts must indulge every reasonable presumption against finding a waiver of the fundamental right to counsel. A waiver may take the form of an express statement by the accused relinquishing the right to counsel, or under certain circumstances, a waiver can be implied from the facts of a case. An implied waiver of counsel resulting from a defendant's misconduct is more accurately described as a forfeiture of the right rather than a deliberate and informed decision to waive the right. A defendant's lack of good faith in working with appointed counsel, including an unreasonable refusal to cooperate with counsel or an unreasonable request for substitution of appointed counsel, can be the first step toward waiver of counsel. A request for new counsel is ordinarily not a waiver of the right to counsel, but an unwarranted request or a request made without good cause may lead to waiver of the right. People v. Arguello. For this reason, when an indigent defendant voices objections to court-appointed counsel, the trial court has the obligation to inquire into the reasons for the dissatisfaction. If the defendant can establish good cause, such as a conflict of interest, a complete breakdown of communication, or an irreconcilable conflict which leads to an apparently unjust verdict, the court is required to substitute new counsel. Before change of counsel is warranted, the trial court must verify that the defendant has some well-founded reason for believing that the appointed attorney cannot or will not completely represent him. A trial judge may properly inquire into the circumstances without infringing on the attorney-client privilege to determine whether substitution of counsel is warranted. That's People v. Schulteis, 638 Pacific 2nd, 8, Colorado Supreme Court, 1981. In People v. Bergerud, 223 Pacific 3rd, 686, Colorado Supreme Court, 2010, the court set forth 4 factors that should be considered in evaluating a defendant's request for new counsel. 1, the timeliness of the motion. 2, the adequacy of the court's inquiry into the defendant's complaint. Deciding whether a defendant is entitled to substitute counsel requires an inquiry laden with factual determinations. Thus, when an indigent defendant voices objection to court-appointed counsel, the trial court has the obligation to inquire into the reasons for the dissatisfaction. People v. Arguello, People v. Garcia, which is found at 64 Pacific 3rd, 863. Before a substitution of counsel is warranted, the court must establish that the defendant has some well-founded reason for believing that the appointed attorney cannot or will not completely represent him. In performing such an inquiry, a court may inquire as to pertinent details of a disagreement between a defendant and counsel without infringing on the attorney-client privilege. Inquiry into counsel's conversations with the defendant may be critical to a proper assessment of counsel's litigation decisions, U.S. v. Strickland. Unless the complaint underlying a request for substitution of counsel is sufficiently detailed, the court may not rule on the motion without conducting a proper hearing at which both attorney and client testify as to the nature of the conflict. Citations omitted there in the outline. 3, whether the attorney-client conflict is so great that it resulted in a total lack of communication or otherwise prevented an adequate defense. And 4, the extent to which the defendant substantially and unreasonably contributed to the underlying conflict with his attorney. If the trial court appropriately has determined that a substitution of counsel is not warranted, the court can insist that the defendant choose between continued representation by existing counsel and appearing pro se. In this context, a defendant must be given a clear choice between present counsel and waiver of counsel. A defendant who then refuses, without good cause, to proceed with able appointed counsel has effected a voluntary waiver. However, even if the choice to proceed pro se is voluntary, the waiver is not valid until the court ensures that the waiver is made knowingly and intelligently. A waiver cannot be knowing and intelligent unless the record clearly shows that the defendant understands the nature of the charges, the statutory offenses included within them, the range of allowed punishments. A sample advisement is attached to these materials. The following are practice pointers. Have a copy of Arguello and Bergerud on your bench and be familiar with them. You will frequently know when there's a conflict between the defendant and his counsel prior to taking the bench, and you can brush up on the law before taking the bench. Excuse the prosecutor from the hearing. Prior to asking either the defendant or his lawyer any questions about the issue, swear them both in and ask them questions under oath. Most importantly, don't be afraid to take a recess to gather your thoughts or consult with colleagues, even if you have 500 jurors downstairs and the defendant's request to fire his counsel comes up on the morning of trial. If the defendant determines to proceed pro se, make findings that his waiver of the right to counsel is voluntary, knowing, and intelligently made.